we have feared as far as the Supreme Court is concerned seems to be coming true. Can you explain what this update at the court is?
Yeah, Brian, we finally have the brief from the Department of Justice in the very important Voting Rights Act case out of Louisiana. And this brief is a blockbuster, and not in a good way. The Department of Justice, after 70 years of being the keeper of the Voting Rights Act, the agency under Democrats and Republicans that have sought to protect and ensure that minority voters do not have their voting rights diluted. Well, the Trump Department of Justice has filed a brief saying that Section 2 of the Voting Rights Act, the test that has been used to protect Black voters, minority voters, it should be rewritten and essentially gutted so that states would have much freer reign to draw maps that discriminated against Black voters, had the effect of discriminating against Black voters. This is a dark day for democracy, but I can promise everyone we are going to fight this. We are not going to bow down to Donald Trump and his Department of Justice, and we are going to insist that the U.S. Supreme Court stand by decades upon decades of its own precedent and reject this effort to undermine minority voting rights.
Mark, just so that folks who are watching right now can appreciate the gravity of this case in particular, can you explain a little bit of what would happen in the event that Section 2 of the Voting Rights Act is gutted at the hands of the Supreme Court?
Yeah, and this case is a good illustration, right? Louisiana, after the 2020 census, drew a map that failed to protect the rights of its Black citizens. It drew a map with one rather than two Black opportunity districts, which is just a fancy way of saying they created maps that disadvantaged Black voters in violation of federal law, in violation of a federal law first passed by Congress in 1965. It has been updated on a bipartisan basis ever since. Until recently, it was viewed by Republicans and Democrats alike as the crown jewel of American democracy. Well, my law firm and others brought a lawsuit that struck down that first map and required a new map that complied with the Voting Rights Act. The state of Louisiana passed that new map, and that is why, as we record this today, after the 2024 election, there are now two rather than one Black candidates of choice in the congressional delegation in Louisiana. Well, what happened next is to be predicted. A group of white, non-Black plaintiffs brought a challenge saying that this new map violates their rights. And this is the kind of case that should have just been dismissed out of hand. And in fairness to the trial court, it was dismissed, like it was rejected. But the U.S. Supreme Court has taken this case up, and there will be argument in it, actually re-argument in it this October. It was heard last term. And rather than the Supreme Court just rejecting this with the back of the hand, they considered it and set it for this re-argument in October. And so we have been waiting to see what position the parties take in this case relative to the positions they took when it was heard last term. Now, last term, the state of Louisiana defended this map, and the Department of Justice defended this map, along with the parties that were involved in litigation. Well, now we see the state of Louisiana and its officials backing away from this map. They're now retreated and said that this map should be struck down, even though they enacted it. And now, in this blockbuster filing, the DOJ itself has reversed its position. Not just its position in this case, though, Brian. Its position in literally dozens upon dozens of cases where both Democratic and Republican attorneys general and their solicitor generals have defended the Voting Rights Act under the so-called Jingles test, which has been in place now for decades. And what they want to replace it with, Brian, is something that would be the Voting Rights Act in name only. You know, it would basically say that unless the map that is being offered by plaintiffs to replace an illegal map, unless it essentially accomplishes the same political objectives as the state on a partisan basis and can therefore sort of deconstruct race from party, and the initial map intentionally discriminated based on race, the state's map stands. Well, that's an impossible test. I mean, you know, where you have Black voters voting overwhelmingly for Democratic candidates, you're never going to be able to disentangle race from party. So what they're basically saying is, if the state of Louisiana discriminates against Black voters, too bad, unless those Black voters can show that they can pass a map that will still favor Republicans while vindicating the right of Black voters. It's nonsensical. It is cynical. But we're going to fight it, and we're going to prevent this from going into effect.
Just to